Chapter 7. Law and the Violation of Law. The Russkaya Pravda, the oldest juridical memorial of the Kiev period of our history, has all in all, amongst its 43 articles, the so-called, quote, academic list, only 2 articles which do not refer to violations of criminal or civil law. All remaining articles either define sanctions or contain procedural rules to be applied in case of offenses against the law. Hence, deviation from the norm is a prerequisite in both cases. The so-called barbaric laws of the Germanic tribes reveal a similar picture. Thus, for instance, of the 408 articles of Salic law, only 65 do not have a penal character. The most ancient memorial of Roman law, the laws of the 12 tables, begin with the regulation dealing with the summons before court. See in just vocat nin it antest amino igitur in capito. The well-known historian Maine says in his book Ancient Law, quote, "It may be laid down, I think, that the more archaic the code, the fuller and the minuter is its penal legislation." End quote. Non-acquiescence to the norm, violation of the norm, rupture of normal intercourse and resulting conflict is the point of departure and main content of archaic legislation. Yet the normal as such is not prescribed at first. It simply does not exist. The need to fix and determine precisely the extent and the content of mutual rights and obligations first arises when calm, peaceful existence is disrupted. From this point of view, Bentham is right in saying that law creates right by creating crime. Historically, the specific traits of legal intercourse were acquired primarily as a result of actual violation of the law. The concept of theft arose before the concept of property. The relations arising out of loan are fixed to cover possible default on the part of the debtor. Quote, "If a man claims repayment of a debt from someone else, and the latter balks," end quote, and so forth. The original meaning of the word pactum is not at all contract in general, but is derived from pax, peace. That is to say, it means the peaceful termination of a dispute. The accord marks an end of discord. Accordingly, if private law reflects, in the most direct form, the general conditions of existence of the legal form as such, then criminal law is the sphere in which legal intercourse is most severely tested. It is here that the juridical element first and most crudely detaches itself from everyday life and becomes fully autonomous. The transformation of the actions of a concrete person into the proceedings of a legal party, that is, of a legal subject, is particularly apparent in the court case. In order to distinguish everyday acts and expressions of will from juridical expressions of will, ancient law utilized special, solemn formulae and ceremonies. The drama of court proceedings graphically created a peculiar juridical reality, parallel with the real world. Of all types of law, it is precisely criminal law which has the capacity to affect the individual person in the most direct and unmitigated manner. That also explains why the most intense practical interest has always been focused on criminal law. The law and punishment for the law's infringement are extremely closely linked, so that criminal law plays, as it were, the role of a representative of law as such. It is a part which stands for the whole. Historically, the origin of criminal law is associated with the custom of blood vengeance. Undoubtedly, these two phenomena are genetically very close to one another. However, vengeance really becomes vengeance only because vengeance is followed by fines and sentences. Here, too, it is only the subsequent stages of development, as is so often to be observed in the history of mankind, which render comprehensible the implications contained in the preceding forms. If one approaches the same phenomenon from the opposite end, one can see nothing in it but the struggle for existence, a purely biological fact. For the criminologists, fixated on a later epoch, blood vengeance is synonymous with the jus talionis, that is, with the principle of equivalent requital, whereby the possibility of further vengeance is excluded if the injured party or his clan have avenged the offense. In reality, as Kovalevsky rightly demonstrates, the earliest nature of blood vengeance was completely and utterly different. Clan strife is passed on from generation to generation. Every offense, even that perpetuated in revenge, forms grounds for new blood vengeance. The injured party and his clansmen become in turn those given offense, and so it goes on from generation to generation, often to the point of total annihilation of the warring clans. Vengeance first begins to be regulated by custom and becomes transformed into retribution according to the rule of the jus talionis, quote, an eye for an eye, a tooth for a tooth, end quote. At the time when, apart from revenge, the system of compositions or of expiatory payment is adopted, the idea of the equivalent, this first truly juridical idea, itself originates in the commodity form. Felony can be seen as a particular variant of circulation, in which the exchange relation, that is, the contractual relation, is determined retrospectively, after arbitrary action by one of the parties. The ratio between offense and retribution is likewise reduced to this exchange ratio. This is why Aristotle, when speaking of equalization in exchange as a form of justice, divides this into two subspecies: equalization by voluntary and by involuntary acts. In the process, Aristotle considers the economic relations of buying, selling, loans, and so forth as the former, and all forms of crime which entail a punishment as their equivalent as the latter. Aristotle is also the author of the definition of crime as an involuntarily concluded contract. Punishment emerges as an equivalent which compensates the damage sustained by the injured party. As we know, this idea was also adopted by Hugo Grotius. Naive as these constructs may seem at first sight, these constructs conceal a much finer feeling for the legal form than is to be found in the eclectic theories of modern jurists. In the examples of vengeance and punishment, we can observe with particular clarity the imperceptible nuances by which the organic and biological is related to the juridical. This fusion is heightened by the fact that man is not able to renounce the interpretation of the phenomena of animal life to which he is accustomed, that is, the juridical or ethical interpretation. In the actions of animals, man unintentionally finds the significance which was actually only projected onto them by subsequent development, that is, by the historical development of humanity. Self-defense is one of the most natural phenomena of animal life. It is completely irrelevant whether we find self-defense only as an individual reaction of a lone creature or as a reaction of a collective. According to the evidence of scholars who study the life of bees, the bees guarding the entrance of the beehive attack and sting any bee not belonging to the swarm if it attempts to gain entry to the hive in order to steal honey. Moreover, if a bee from another swarm has already gained access to the hive, it is killed the instant it is discovered. It is not unusual in the animal world to find cases where the reaction is separated by a certain interval of time from the action causing it. the animal does not respond immediately to the attack, but delays this until a later, more suitable time. Self-defense here becomes vengeance in the truest sense of the word. And since, for modern man, vengeance is inextricably linked with the idea of equivalent retribution, it therefore comes as no great surprise that Fairy, for example, wishes to assume the existence of a, quote, juridical, end quote, instinct in animals. In fact, the juridical idea, or the idea of the equivalent, is first clearly delineated and objectively realized at that level of economic development, where this form becomes common as equalization in exchange. This certainly does not occur in the animal world, but in human society. It is entirely unnecessary to this process for expiatory payment to have completely supplanted vengeance. It is entirely unnecessary for this process for expiatory payment to have completely supplanted vengeance. It is precisely in cases where restitution has been refused as something dishonorable, a view prevalent for a long while among primitive peoples, and where the carrying out of personal revenge was regarded as a solemn duty, that the act of vengeance acquires a new nuance, which it did not have when it was not yet an alternative. Now, the idea of vengeance as the only adequate retribution is projected onto it. The reunification of restitution in money from the renunciation of restitution in money form emphasizes, so to speak, that the shedding of blood is the only equivalent for blood already shed. Vengeance is transformed from a purely biological phenomenon into a juridical institution by being linked with the form of equivalent exchange according to values. Archaic penal law emphasizes this connection in a particularly crude and vivid manner, in that it directly equates the damage done to property and injury to the person with a naivete which later epochs shamefacedly renounced. From the standpoint of ancient Roman law, there is nothing strange in the fact that a tardy debtor paid for his debts with parts of his body, in partes sacra, and that the person guilty of bodily harm paid for it with his property. The idea of the equivalent transaction appears here in all its bluntness, uncomplicated and unsoftened by any additional aspects. In accordance with this, criminal procedure assumes the character of a commercial transaction. Quote, "We have here to visualize a transaction in which one side made suggestions and the other bargained, until finally they came to terms. The expression for this was passera, passici, depesici, and for the agreement itself, pactum." Here begins the role of the mediator in ancient Nordic law, chosen by both parties, who determines the sum of money paid as compensation. End quote. Iring. As far as so-called public penalties are concerned, there is no doubt that public penalties were originally introduced primarily for fiscal considerations and served as a means of filling the coffers of the representatives of power. Maine has this to say about it, quote, The state did not take from the defendant a composition for any wrong supposed to be done to itself, but claimed a share in the compensation awarded to the plaintiff simply as the fair price of its time and trouble. End quote. Maine. We know from Russian history that this, quote, fair compensation for time lost, end quote, was exacted so assiduously by the princes that, according to the testimony of the chronicler, quote, the Russian earth was ravaged by wars and penal payments, end quote. The same phenomenon of juridical plundering can be observed not only in Old Russia, but also in the empire of Charlemagne. In the eyes of the princes of ancient Russia, judicial fees were in no way different from their other sources of revenue. They made presents of them to their servants, divided them up, and so on. It was possible to buy oneself free from the princely court by paying a certain sum. Besides public penalty as a source of income, punishment as a means of maintaining discipline and protecting the authority of sacerdotal and military power emerged fairly early. It is well known that in ancient Rome, most serious offenses were simultaneously crimes against the gods. Thus, a violation of law which was very important to landowners, such as the willful displacement of boundary markers, was traditionally viewed as a religious offense, and the guilty person's head fell into the power of the gods. The priestly caste, who acted as the custodians of order, thereby pursued not merely an ideal, but also a very solid material interest. For the fortune of the guilty party was confiscated in their favor in such cases. In other circumstances, even penalties inflicted by the priestly caste for attacks on their revenue, refusal of prescribed ceremonies, or sacrificial offerings, attempts to introduce new religious doctrines of any sort, and so forth, were of a public nature. The influence of priestly organizations, that is, of the church, on criminal law is illustrated by the fact that, although the sentence still retained the character of an equivalent or a retribution, this retribution is no longer directly linked with the loss to the injured party based on his claim, but acquires a higher abstract significance as divine punishment. In this way, the Church attempts to associate the ideological motive of atonement, expiatio, with the material aspect of compensation for the injury, and thus to construct from penal law based on the principle of private revenge a more effective means of maintaining public discipline, that is to say, class rule. The efforts of the Byzantine clergy to have capital punishment introduced in the Principality of Kiev are characteristic of this. The same end, the maintenance of discipline, also determined the nature of the penal measures of military leaders. They sat in judgment over subjected people, as well as over their own soldiers, for plotting military treason or simply for insubordination. The famous story of Clovis, who cracked open the head of a recalcitrant warrior with his own 2 hands, shows how primitive this court was in the days when the barbarian kingdoms of the Germanic tribes were being established. In early days, it was the assembly of the people which had the task of maintaining military discipline. With the strengthening and stabilization of royal power, this function naturally transferred to the kings and became identical with the defense of their own privileges. As for the remaining criminal offenses, for a long period the Germanic kings, as also the princes of Kiev, had a purely fiscal interest in them. This state of affairs changes with the development and stabilization of barriers of rank and class. The emergence of a spiritual and temporal hierarchy highlights the protection of their privileges and the struggle against the lower oppressed classes of the population. The dissolution of natural economy and the increased exploitation of the peasants, which resulted, the evolution of trade and the organization of the state based on rank and class, confront criminal justice with entirely new problems. Criminal justice in this epoch is no longer simply a means for those in power to fill their coffers, but is a means of merciless and relentless suppression, especially of peasants fleeing intolerable exploitation by lords of the manor and the seigneurial estate of impoverished vagabonds, beggars, and so forth. The police, and the investigative apparatus begin to assume the most important function. Penalties become the means of their physical extermination or intimidation. Penalties become means of either physical extermination or intimidation. It is the epoch of torture, of capital punishment, of gruesome forms of execution. Thus the way was gradually prepared for the complex amalgam of modern criminal law. It is a simple matter to distinguish between the historical strata from which it emerged. Basically, that is to say, from the purely sociological standpoint, the bourgeoisie maintains its class rule and suppresses the exploited classes by means of its system of criminal law. In this respect, its courts and its private, quote, voluntary organizations of strikebreakers are pursuing one and the same end. Considered in this light, criminal justice is merely an adjunct of the investigative and police apparatus. Should the Paris courts one day close their portals for a few months, the only people to suffer would be those offenders already arrested. If, on the other hand, the notorious police brigades of Paris were to stop work for just one day, the result would be catastrophic. Criminal justice in the bourgeois state is organized class terror, which differs only in degree from the so-called emergency measures taken in civil war. Spencer long ago drew attention to the complete analogy between, indeed, the identity of defensive action against an external attack, war, and the reaction against disruptive elements in internal state organization, judicial or juridical defense. The fact that measures of the first kind, that is, penal measures, are applied chiefly against elements who have lost their position in society, and that measures of the second kind are mainly employed against the most active fighters of a new class rising to power, alters the principle behind the matter just as little as the greater or lesser uniformity and complexity of the procedure employed. One can only grasp the true significance of the penal practice of the class state by starting from its antagonistic nature. The would-be theories of criminal law, which derive the principles of penalty policy from the interests of society as a whole, are conscious or unconscious distortions of reality. Quote, society as a whole, unquote, does not exist, except in the fantasy of the jurists. In reality, we are faced only with classes, with contradictory, conflicting interests. Every historically given system of penal policy bears the imprint of the class interests, of the class which instigated it. The feudal lord had intractable peasants, and townspeople who opposed his power executed. The Confederate cities hung the robber knights and destroyed their strongholds. In the Middle Ages, every person who tried to follow a trade without being a member of the guild was thought to be a lawbreaker. The capitalist bourgeoisie, scarcely had it emerged, declared that the workers' attempts to join forces in associations were criminal. Thus, class interest impresses the stamp of historical concreteness on every system of penal policy. As regards the individual methods of penal policy, people usually point to the great progress made by bourgeois society towards more humane forms of punishment since the days of Beccaria and Howard. The abolition of torture, of corporal punishment, and humiliating punishments, of gruesome forms of execution, and so on, are relevant here. There is no doubt that all this represents a great step forward. However, one should not forget that the abolition of corporal punishment has not been by any means universally achieved. In England, flogging with a birch is permissible, up to 25 lashes for minors under 16, up to 150 lashes for adults, as punishment for theft and plundering. The cat o' nine tails is used on sailors in England. In France, corporal punishment is used as a disciplinary punishment for prison inmates. In America, in 2 states of the Union, they mutilate offenders by castrating them. Denmark introduced flogging with a rod and with tarred rope ends for a number of offenses in 1905. Only a short time ago, the fall of the Soviet Republic in Hungary was celebrated by the introduction of, amongst other things, caning of adults for a whole series of offenses against the person and against property. Furthermore, it is worthy of note that precisely the last decades of the 1800s and the first decades of the 20th century have seen a perceptible trend in a whole number of bourgeois states towards reintroduction of excruciatingly painful and humiliating punishments as deterrents. The humanism of the bourgeoisie is replaced by the demand for severity and the more frequent application of the death sentence. Kautsky tries to explain this by the fact that, at the end of the 18th and the beginning of the 19th centuries, in other words, until the introduction of universal military service, the bourgeoisie had a peaceful and humane disposition, because the bourgeoisie did not serve in the army. Surely this can scarcely be the main reason. More important is the transformation of the bourgeoisie into a reactionary class, fearing the rise of the working class movement, and lastly the policy of colonialism, which has been a school of cruelty all along. Only the complete disappearance of classes will make possible the creation of a system of penal policy which lacks any element of antagonism. Moreover, it is very doubtful whether in such circumstances there will be any necessity at all for a penal system. If the penal practice of the state power is by nature and in its content a weapon for the protection of class rule, then it will appear in its form as an aspect of the legal superstructure and will be absorbed into the legal system as one of its branches. We have already shown that the naked struggle for existence takes on juridical form through the projection into it of the principle of equivalence. Thus the act of self-defense ceases to be purely self-defense and becomes a form of exchange, a peculiar form of circulation, which has its place alongside normal, in quotes, commercial circulation. Crime and punishment become what crime and punishment are. In other words, crime and punishment take on a juridical stamp through a buying-off transaction. To the extent that this form is retained, the class struggle takes place in the form of the administration of justice. Conversely, the characterization of, quote, criminal law end quote. Conversely, the characterization, quote, criminal law, end quote, becomes utterly meaningless if this principle of the equivalent relation disappears from it. Hence, criminal law, insofar as criminal law is a variation of that basic form to which modern society is subject, precisely the form of equivalent exchange, with all its consequences, becomes a constituent part of the legal superstructure. The materialization of this exchange relation in criminal law is one aspect of the constitutional state as the embodiment of the ideal form of transaction between independent and equal commodity producers meeting in the market. However, since social relations are not confined to the abstract relations between abstract commodity owners, so too, the criminal court is not only an embodiment of the abstract legal form, but is also a weapon in the immediate class struggle. The sharper and more bitter this struggle, the more difficult it will be for class rule to be realized within the legal form. When that happens, the, quote, impartial, end quote, court and its legal guarantees will be ousted by an organization of unmediated class violence, with methods guided by considerations of political expediency alone. If one regards bourgeois society as a society of commodity owners, one would assume a priori that its criminal law would be, quote, most juridical, end quote, in the sense illustrated above. Yet we appear here to be confronted with various difficulties right from the start. The first difficulty is the modern criminal court. The first difficulty is that modern criminal law starts out not at all from the damage suffered by the injured party, but from the violation of the norm established by the state. Yet if the injured party with his claim steps into the background, one might well ask what then has become of the equivalent form. Nevertheless, in the first place, however much the injured party may fade into the background, he does not disappear altogether. He continues to signify the context of the criminal action taking place. The abstraction of injured public interest is based on the perfectly real figure of the injured party, who takes part in the trial, either personally or through a representative, and gives the trial its living meaning. Furthermore, this abstraction is personified in a real way, even in those cases where there is in fact no injured party, and only the law, quote, starts up in anger, end quote, in the person of the public prosecutor. This split, whereby state power appears not only in the role of plaintiff, public prosecutor, but also in the role of judge, illustrates that the criminal case as a legal form is inseparable from the figure of the injured party, demanding, quote, satisfaction, end quote, and accordingly from the more general form of legal transaction. The public prosecutor demands, as befits a, quote, party, end quote, a, quote, high, end quote, price. That is to say, a severe sentence. The offender pleads for leniency, for a, quote, discount, end quote, and the court passes sentence, quote, in equity, end quote. If one were to reject this form of transaction completely, one would deprive criminal proceedings entirely of their, quote, juridical soul, end quote. Imagine for a moment that the court was really concerned only with considering ways in which the living conditions of the accused could be changed, that either he was improved or society was protected from him, and the whole meaning of the term, quote, punishment, end quote, evaporates at once. This does not mean that all of penal, judicial, and executive procedure is totally devoid of the above-mentioned simple and understandable elements. We merely wish to demonstrate that this procedure contains particular features which are not fully dealt with by clear and simple considerations of social purpose, but represent an irrational, mystified, absurd element. We wish also to demonstrate that it is precisely this which is the specifically legal element. There appears to be a further difficulty in the following. Archaic criminal law knew only the concept of injury. Guilt and blame, which are given such a prominent position in modern criminal law, were totally absent at this stage of development. The deliberate act, the negligent act, and the accidental act were judged only by their consequences. The customs of the Salic Franks and of the present-day Ossetians are, in this respect, on the same level of development. For example, the latter do not differentiate between death caused by a stab with a dagger and death occurring as the result of a stone knocked from a bull's foot rolling down the mountain. Knocked by a bull's foot rolling down the mountain. As we can see, it does not in any way follow from this that the concept of liability as such was unknown to ancient law. It was simply differently determined. In modern criminal law, the concept of strictly personal liability corresponds to the radical individualism of bourgeois society. In contrast to this, the law of antiquity was permeated by the principle of collective liability. Children were punished for the sins of their fathers, and gens were liable for every member of the gens community. Bourgeois society undermines all hitherto prevailing primitive and organic bonds between individuals. It proclaims the principle of, quote, every man for himself, end quote, and follows it with absolute consistency in all spheres, including criminal law. Furthermore, modern criminal law has introduced a psychological element into the concept of liability, thereby making it flexible. It has broken it down into degrees: liability for a foreseen outcome, premeditation, and liability for an outcome not foreseen, but foreseeable, negligence. Finally, it postulated the concept of not being answerable for one's actions, that is, complete absence of any liability. It goes without saying that the introduction of the psychological element into the concept of liability implied the rationalization of the fight against crime. A theory of prevention in general, and in particular, could be postulated only on the basis of differentiating between being responsible or not being responsible for one's actions. Nevertheless, to the extent that the relationship between the offender and the sentencing power was construed as a legal relation and took the form of a juridical trial, Nevertheless, to the extent that the relationship between the offender and the sentencing power was construed as a legal relation and took the form of a judicial trial, this new element did not in any way eliminate the principle of equivalent retaliation. On the contrary, it created a new basis for its application. What does this breakdown mean, if not the differentiation of conditions to be applied in a future judicial transaction? Shading responsibility is a basis for shading the punishment. It is a new, and if you like, an ideal or psychological element which is taken into account, together with the material aspect of the damage and objective aspect of the deed, to provide collectively the basis for determining the degree of punishment, for a premeditated act, the gravest responsibility, therefore under otherwise unchanged circumstances, also the most severe punishment. Negligent action, a less grave responsibility. Ceteris paribus, a lesser sentence. Finally, no responsibility. The perpetrator cannot be held to account for his actions. Punishment waived. If, in place of punishment, we substitute treatment, that is to say, a concept of medical health, what follows is entirely different, since we would then be interested not primarily in whether the punishment fits the crime, but in whether the measures taken are adequate to the goals set, that is, whether they are adequate to the protection of society, to having an effect on the offender, and so forth. From this point of view, it can easily be the case that the relationship is a completely inverse one. In other words, that the most intensive and most prolonged measures of influence are required, precisely where there is a case of diminished responsibility. If the punishment functions as a settlement of accounts, the notion of responsibility is indispensable. The offender answers for his offense with his freedom. In fact, with a portion of his freedom corresponding to the gravity of his action. The conception of liability would be quite superfluous in a situation where punishment has lost the character of an equivalent. Were there really no trace of the principle of equivalence remaining, then punishment would entirely cease to be punishment in the juridical sense of the word. The juridical concept of guilt is not a scientific concept, since the juridical concept of guilt leads directly to the contradictions of indeterminism. From the standpoint of linking the causes which bring about some event, there is no basis for giving prominence to one link in the chain over another. The actions of a physically abnormal person, not answerable for his actions, are no less determined by a series of causes, heredity, living conditions, environment, and so on, than are the actions of completely normal, fully accountable persons. It is interesting that punishment applied as a pedagogical measure, I think that's what it says. It is interesting that punishment applied as a pedagogical measure, I think it's pedagogical, just spelled weird. That is to say, outside the notion of equivalence, is in no way connected with the conception of responsibility, freedom of choice, and the like, nor does it have need of this conception. In pedagogy, the appropriateness of punishment, of course we are speaking here of appropriateness in the most general sense, regardless of the form or of the mildness or severity of the punishment, is determined solely by the ability to gain an adequate grasp of the connection between one's own actions and their disagreeable consequences, and to retain this in one's memory. Persons whom criminal law regards as not responsible for their own actions, such as children of a very tender age, physically abnormal people, and others, are also responsible in this sense, in that they are open to being influenced by in a particular direction. In principle, punishment in keeping with the guilt represents the same form as retaliation in proportion to the injury. Its most characteristic feature is the arithmetical expression of the severity of the sentence. So and so many days, weeks, and so forth, deprivation of freedom, so and so high a fine, loss of these or those rights. Deprivation of freedom, for a period stipulated in the court sentence, is the specific form in which modern, that is to say bourgeois capitalist criminal law, embodies the principle of equivalent recompense. This form is unconsciously yet deeply linked with the conception of man in the abstract, and abstract human labor measurable in time. It is no coincidence that this form of punishment became established precisely in the 19th century, and was considered natural at a time, that is, when the bourgeoisie was able to consolidate and develop to the full all its particular features. Prisons and dungeons did exist in ancient times, and in the Middle Ages too, in addition to other means of physical violence. But people were usually held there until their death, or until they bought themselves free. For it to be possible for the idea to emerge that one could make recompense for an offense with a piece of abstract freedom determined in advance, it was necessary for all concrete forms of social wealth to be reduced to the most abstract and simple form, to human labor measured in time. Here we undoubtedly have a further example of the dialectical connection between the various aspects of culture. Industrial capitalism, the Declaration of Human Rights, the political economy of Ricardo, and the system of imprisonment for a stipulated term are phenomenon peculiar to one and the same historical epoch. Yet, while the equivalence of the punishment in its crude, brutal, physical, material form, infliction of a physical injury, or exacting expiatory payment, maintains its simple meaning, accessible to everyone precisely through this crudity, it loses this clear meaning in its abstract form. Deprivation of freedom for a stipulated period, even though people continue to describe the degree of punishment here, too, as proportionate to the gravity of the deed. It is for this reason also that many criminologists, particularly those who consider themselves to be progressive, are quite naturally at pains to eliminate altogether this element of equivalence, which has patently become absurd, and to concentrate their attention on the rational goals of the punishment. The error these progressive criminologists make is that when they criticize the would-be absolute theories of punishment, these progressive criminologists think they are confronted only with mistaken views, confused thinking, which could be countered by theoretical critique alone. In reality, this absurd equivalent form results not from the aberrations of individual criminologists, but from the material relations of the society based on commodity production that nourish it. The contradiction between the rational purpose of protecting society, or of reforming the criminal, and the principle of equal equivalent recompense does not exist in books and theories alone, but in life itself, in judicial practice, in the very structure of society, just as the contradiction between the fact that people in general are bound together by their labor, and that the absurd form of expression of this bond, the value of commodities, is to be found not in books and theories, but in social practice itself. To substantiate this, we have only to consider at length a few aspects. If, in social life, the purpose of punishment was really the only consideration, then the execution of sentence, and more particularly its outcome, must excite the keenest interest. Yet, it cannot be denied that, in the overwhelming majority of cases, the main emphasis in a critical trial is to be found in the courtroom at the moment of the verdict. The interest shown in the protracted methods of influencing the offender is negligible, compared with the interest aroused by the telling moment of the verdict and the determination of the, quote, degree of punishment, end quote. Only a small circle of professionally interested people are concerned about questions of prison reform. The focus of attention, as far as the public is concerned, is whether the sentence corresponds to the gravity of the offense. If opinion in general is satisfied that the court has determined the equivalent correctly, then everything is, so to speak, settled, and the subsequent fate of the offender is of further interest to practically no one. the, quote, execution of the sentence, end quote, thus bemoans Krona, one of the best-known specialists in this field. Quote, is the problem child of criminal law, end quote. In other words, it is relatively neglected. Krona goes on, quote, even if you have the best law, the best judge, the best verdict, but the official responsible for the execution of sentence is incompetent, then you might as well throw the law into the waste paper basket and burn the verdict, end quote. Krona. But the dominance of the principle of equivalent retribution is not only expressed in this distribution of public interest. It is manifested in a similarly crude manner in judicial practice itself. There could be no other conceivable basis for the verdicts which Aschaffenburg cities. There could be no other achievable basis for the verdicts which Aschaffenburg cites in his book, Crime and Its Prevention. We shall here select but two examples from a whole series. A relapsed offender with 22 prior convictions for forgery, theft, fraud, and so on, is sentenced for the 23rd time, this time to 24 hours imprisonment for insulting an official. Another who has spent in all 13 years in prison and penitentiary, and has 16 prior convictions on charges of robbery and fraud, is given a 4-month sentence for fraud, his 17th sentence. Obviously, one cannot speak either of a defensive or of a reformatory function of the punishment in these cases. It is the formal principle of equivalence which triumphs here. Punishment equivalent to the guilt. What else could the court have done? It cannot hope to reform an inveterate habitual offender by 3 weeks' detention, nor yet can it lock up the person in question for life, just for insulting an official. The court has no choice but to allow the offender to pay for his petty crime in small change, so many weeks' loss of freedom. For the rest, bourgeois administration of the law sees to it that the transaction with the offender should be concluded according to all the rules of the game. In other words, anyone can check and satisfy themselves that the payment was equitably determined. Public nature of court proceedings. The offender can bargain for his liberty without hindrance, adversary form of the trial, and can avail himself of the services of an experienced court broker to this end, admission of counsel for the defense, and so on. In a word, the state's relations with the offender remain throughout well within the framework of fair trading. In this precisely lie the so-called guarantees of criminal proceedings. The offender must therefore know in advance what he is up for, and what is coming to him. Nullum crimen, nulla poena, sine lega. What is the implication of this? Is it necessary for every potential criminal to be informed in minute detail about the corrective methods which would be used on him? No, it is much simpler and more brutal. He must know what quantity of his freedom he will have to pay as a result of the transaction concluded before the court. We must know in advance of the conditions under which payment will be demanded of him. That is the important import of criminal codes and criminal procedures. One should not make the mistake of imagining the matter to be such that whereas the mistaken theory of retribution dominated criminal law in the former times, it was later superseded by the correct viewpoint of social protection. It would be wrong to consider the development as if it were taking place on the plane of ideas alone. In reality, sentencing policy contained social elements, both before and after the emergence of the sociological and anthropological tendencies in criminology. Alongside these, however, it contained and still contains elements which do not arise from this technical purpose and do not therefore allow criminal procedure to be expressed absolutely and completely in the rational, non-mystified form of social technical regulations. These elements, whose origin should be sought not in sentencing policy as such, but much deeper, give the juridical abstractions of crime and punishment their reality, and ensure them their practical significance in the framework of bourgeois society, despite all the efforts of the theoretical critique. At the Hamburg Congress of Criminologists in 1905, Van Hammel, a reputable representative of the sociological school, declared that the main obstacle to modern criminology. At the Hamburg Congress of Criminologists in 1905, Van Hammel, a reputable representative of the sociological school, declared that the main obstacles to modern criminology were the three concepts of guilt, crime, and punishment. If we freed ourselves of these concepts, he added, everything would be better. One might respond to this that the forms of bourgeois consciousness cannot be eliminated by a critique in terms of ideas alone, for they form a united whole with the material relations of which they are the expression. The only way to dissipate these appearances, which have become reality, is by overcoming the corresponding relations in practice, that is, by realizing socialism through the revolutionary struggle of the proletariat. It is not enough to label the concept of guilt as a prejudice, in order to be able to introduce immediately in practice a sentencing policy which actually makes this concept superfluous. So long as the commodity form and the resultant legal form continue to make their mark on society, so in judicial practice too, the essentially absurd idea, absurd that is from the non-juridical viewpoint, that the gravity of each crime can be weighed on some scale and expressed in months or years of prison detention, will retain its force and its meaning in real terms. One can, of course, refrain from proclaiming this idea in such a brutally offensive formulation, but that does not yet imply that one thereby escapes its influence entirely in practice. Changing the terminology does not alter anything in the substance of the matter. The People's Commissariat for Justice in the Federated Russian Socialist Soviet Republics published guidelines for criminal law as early as 1919, in which the principle of guilt as the basis of punishment is rejected, and the punishment itself is characterized not as retribution for guilt, but solely a protective measure. The 1922 Penal Code of the RSFSR likewise does without the concept of guilt. Finally, quote, the quote, principles of penal legislature of the Union, end quote, passed by the Central Executive Committee of the Soviet Union, eliminate the term, quote, punishment, end quote, altogether, replacing it with the term, quote, judicial corrective measures of social defense, end quote. Such an alteration in the terminology undoubtedly has a certain demonstrative value. Nevertheless, the declarations do not decide the merits of the case. Transforming punishment from retribution into a measure of expediency for the protection of society, and into the reform of individuals who are at threat, into transforming punishment from retribution into a measure of expediency for the protection of society, and into the reform of individuals who are a threat to society, calls for the completion of a colossal organizational task. Not only does this task lie beyond the sphere of purely judicial activity, but it would actually, in the event of its being completed successfully, render the court case and court verdict totally superfluous. For when this task has been fully accomplished, the reforming influence will no longer be a simple, quote, legal consequence, end quote, of the court's verdict, in which some, quote, evidence, end quote, has been deposed, but will acquire a completely independent social function of a medical educational nature. There is no doubt that our development is proceeding and will continue to proceed in that direction. For the present, however, so long as we continue to have to lay emphasis on the word, quote, judicial, end quote, when speaking of measures of social defense, so long as the forms of the judicial process and of the material penal code are still retained, altering the terminology will remain a largely formal reform. This fact did not, of course, escape the notice of the jurists who have written about our penal code. I will cite here only a few opinions. Polyansky finds that in the specific section of the penal code, quote, the negation of the concept of guilt is purely superficial, end quote, and that, quote, the question of guilt and of the degree of guilt is thrown up daily in the present-day practice of our courts, end quote. Isayev says that the concept of guilt, quote, is not alien to the 1922 Penal Code, for since it differentiates premeditation from negligence by contrasting these two cases with one another, it also distinguishes between punishment and social protective measures in the more narrow sense, end quote. Isayev. Of course, the fact is that both the penal code in itself and the judicial process for which it is designed are permeated by the juridical principle of equivalent recompense. What else is the general section of every penal code, including ours, with its concepts of aiding and abetting, complicity, attempt, preparation, and so forth, if not a method of weighing guilt more accurately? What should the distinction between premeditation and negligence be but a delineation of degrees of guilt? What is the point of the concept of not being responsible for one's actions if the concept of guilt does not exist? And finally, why is there a need for the whole particular section if it is merely a matter of social class-based protective measures? A consistent realization of the principle of social protection would not require the establishment of particular evidence with which the degree of punishment determined by law or by the court is logically connected, but would require an exact description of the symptoms characterizing the socially dangerous situation and an exact elaboration of the methods to be used in each individual case in order to avert the danger to society. The salient point is not, as many people think, merely that the social protective measure is linked in its application with subjective elements, the nature and extent of the risk to society, while the punishment is based on an objective element, that is, on concrete evidence as defined in the particular section of the Penal Code. The salient point is the nature of this connection. It is difficult for the punishment to free itself from its objective basis, because the punishment cannot throw off the form of equivalence without losing its fundamental characteristic. Yet only concrete evidence provides any likeness to a quantifiable entity and is thus a certain sort of equivalent. A person can be forced to expiate a certain action, but there is no sense in forcing him to atone for the fact that society considers him, the subject in question, to be dangerous. That is why punishment is predicated on precisely established evidence, which the social protective measure does not require. Compulsory atonement is juridical coercion. Compulsory atonement is juridical coercion addressed to the subject from within the formal framework of the trial, the verdict, and the execution of sentence. Coercion as a protective measure is an act of pure expediency and as such can be governed by technical regulations. These regulations can be more or less complex, according to whether the purpose is the mechanical elimination of the dangerous individual or his reform. In either case, however, these rules express in clear and simple terms the goal society has set itself. In the legal norms which prescribe particular punishments for particular crimes, on the other hand, this social purpose appears in masked form. The individual who is subjected to influence is put in the position of a debtor settling his debt. It is no accident that the word, quote, execution, end quote, is used for the compulsory fulfillment of private law obligations, as well as for disciplinary penalties. The term, quote, to serve a sentence, end quote, also expresses the same thing exactly. The offender who has served his sentence returns to his point of departure, that is, to his isolated existence in society, to the, quote, freedom, end quote, to enter into obligations, and to perpetrate punishable deeds. Criminal law, like law in general, is a form of intercourse between isolated egoistic subjects. The bearers of autonomous private interests or ideal property owners. The more wary of the bourgeois criminologists are not at all ignorant of this connection between criminal law and the legal form in general. In other words, of the fundamental conditions without which a society of commodity producers is inconceivable. This is why their very reasonable response to the demands of the extreme representatives of the sociological and anthropological schools, that they should lay the concept of crime and guilt to rest, and that they should put an end to the juridical elaboration of criminal law altogether, is the question. In that case, what about the principle of civil liberty, the guarantees of procedural regularity, the principle of nullum crimen sine lega, and so on? That is exactly the position taken by Żubiński in his polemic against Ferry and Dorado, among others. I quote a characteristic passage. Quote, while giving his, Dorado's, glorious belief in the unlimited power of scholarship full credit, we prefer to remain on firm ground, that is, to reckon with the lessons of history and the actual facts of reality. In doing so, we shall be forced to admit that it is not, quote, enlightened and rational, end quote, free will which is required, which guarantees that this will indeed be enlightened and rational, with guarantees that this will indeed be enlightened and rational, but a firm legal system for whose maintenance juridical study will continue to be necessary, end quote. Żubiński. The concepts of crime and punishment are, as is clear from what has been said already, necessary determinants of the legal form, from which people will be able to liberate themselves only after the legal superstructure itself has begun to wither away, and when we begin to overcome, and to do without these concepts in reality, rather than merely in declarations, that will be the surest sign of the narrow horizon of bourgeois law is finally opening up before us.